The controversy involved in these appeals lies in a narrow compass, as would be clear from the few facts mentioned herein below. Two persons, namely Santosh Kumar and Hira Singh, filed their claim petitions before the competent authority under the Minimum Wages Act 1948. In these claim petitions, the respondents claimed that they had worked with the appellant on her land for the period from 1/1/1991 to 30/10/1992, but she did not pay them their legitimate wages despite rendering their services for her. This, in substance, was their grievance. The two applicants, within bracket workers oblique employees, therefore, claimed that their legitimate wages for the period in question be determined in the light of the provisions of the Act, and the claimants be accordingly paid their minimum wages for the period in question by the appellant. The appellant contested the matter. An inquiry was accordingly held. Report from the concerned authority was also called for. By order dated 29/10/1995, the competent authority allowed the claim petitions of the two workers and accordingly directed the appellant within bracket employer to pay them wages as determined along with the penalty amount awarded by the authority. The appellant felt aggrieved and filed appeal before the appellate authority under the Act. By order dated 8/10/1996, the appellate authority dismissed the appeal and affirmed the order of the competent authority. The appellant felt aggrieved and filed writ petition in the High Court at Patna. By orders dated 31/3/1998 and 22/4/1998, the single judge of the High Court dismissed the writ petitions. By impugn orders, the division bench dismissed the appeals which have given rise to filing of these appeals by way of special leave by the appellant within bracket employer in this court. The short question which arises for consideration in these appeals is whether the High Court was justified in upholding the orders passed by the two authorities under the Act. We have heard Mr. Vivek Singh, learned counsel for the appellant, and Mr. Gopal Singh, learned counsel for the respondents, and have also perused the written statements filed by the counsel for the appellant. Having heard the counsel for the parties, and on perusal of the record of the case and the written submissions of the learned counsel, we find no merit in these appeals. In our considered opinion, no case has been made out to call for any interference in the impugn orders for more than one reason. Firstly, what is involved in this case is a pure question of fact which cannot be gone into in these appeals. Secondly, the question as to whether the two workers ever worked with the appellant, and if so, for how much period and how much wages were payable to them by their employer, are the material questions which were gone into by the competent authority and appellate authority and decided in favor of the two workers.